Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. This tail right here is a little bird and we would both like to welcome you to All Up in Your Business, where today we are going to go through your comments and answer your questions and generally just sit here and be tiny, sweet, adorable little angels. Check the description for links to some additional information and resources. Keep in mind during this video that I am a lawyer, but I am not your lawyer. So the stuff that I talk about here is not to be taken as a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer who's licensed in your state. If you have been a watcher of All Up in Your Business for a while, or I guess even if not, if you're new here, stick around till the end of the video if you want to get a little bit of insight into the future of All Up in Your Business. I have some updates and some things might be changing here soon. So if you're curious about what is in store for All Up in Your Business, or if you're just curious about what's going on in my business, make sure you stick around till the end of the video. Let's get into your questions. The first one, yay, is easy. How do I find your Brandish? I'm so glad I found you on YouTube. Brandish is my online DIY trademark course where I teach you step by step how to get a trademark registered with the USPTO without a lawyer. How do you find it? You can go to brandish.legal to learn more and sign up for that. I'll link to it down in the description as well. Don't worry, it'll be down there. I disagree. I don't remember exactly what this person is disagreeing with. Maybe we'll find out. You shouldn't start a business in the first place if you aren't committed 100% to it. That said, when you start that 100% committed business, you should be committed to the name. You can't gain traction to be successful if you aren't branding. Branding is everything. The name and logo is what gets you repeat customers. It's what gets advertised. You get word of mouth based on your name and in many cases your logo. The only time none of it matters is if you are just out to make a few quick bucks and not at all interested in providing quality services or products. If you find you want to change the logo, just put in for a new one, upkeep the old one with the USPTO for a time to cover transition of labels, protecting your brand, getting used by someone who is looking to capitalize what we created, old brand label, blah, blah, blah. Okay, that's a lot of words. I disagree with you, person, sir or madam. You shouldn't start a business in the first place if you aren't 100% committed to it. Commitments change. We don't know. We don't always know right off the bat. Being a little, on the fence about a business, I don't think should stop you from going for it. Hopefully, yeah, ideally you're 100% committed to it, but if you're like, let's give it a try and see what works, go for it. You should also be 100% committed to the name. The things change, your business changes. I started my law practice in 2013 and I changed the name. I changed the name a few years in because stuff changed. The way I wanted to brand changed. Even big, massive companies change their branding. It happens. It's part of business. Business change. The business landscapes change. Your consumers change. The stuff you sell, the industry changes. Shit changes. So you might think you're 100% committed to some branding, but it might change. It will most likely change at some point. I'm not going to get too much into this, but if not being 100% committed is going to stop you from going for something, I don't think that's good. Go for it. If you change your mind, that's fine. You can change your mind. You can change your branding. Stuff changes. So I have a question on the goods and services part about trademarks. Let's say I have a trademark for 3 types of vitamins at the time of trademark DOB, and I later expanded my product line by 3 more types of vitamins. Does my trademark work for all 6 if they are still the same type of goods, or do I have to go back and add those 3 new vitamins to be valid? By trademark, I am simply asking about the name and logo as a brand name. I would guess that shoes might be different animal, being that you start off with running shoes, then add high heel or pump as it being completely different market. So it all depends on exactly how you describe your goods and services on the trademark registration. You can just say your trademark can be registered with vitamins. So it doesn't matter if you offer 3 types or 6 types or 1 type or 100 types. Your registration can be just nutritional supplements even, which as a broad category would include vitamins and maybe protein shakes and other supplements. Or you could be very specific with your registration and say vitamin C supplements, vitamin D supplements. So it depends. If you take a broader description though, then no, you don't have to go back and add anything because it's all vitamins. Same with shoes. Actually, you can register your trademark with running shoes and then later on go in and register it with high heels or pumps. But you can also just register it with shoes or footwear. And then that way it doesn't matter. Which one you want to do depends sometimes. Generally speaking, the broader categorization is going to be better because we don't have to worry about what if we launch high heels later on. But that's not always the case. The answer is it depends, but usually you don't have to get that specific with your registrations. Very helpful info. Thank you. Thank you. I have a question about commingling finances. We're a relatively new LLC and aren't getting a ton of revenue yet. So some projects we must fund with personal income. We also have day jobs. We do also have a business checking account. So in this case, is it a problem to personally fund some projects? Is it a problem? Maybe, probably not. That in itself, the sole act of personally funding some business projects, that's probably not going to be enough to pierce the corporate veil kind of thing, which is what this question's getting at, or hold you as the member liable and be considered commingling funds and stuff. It's if you're doing that and you're, treating the business bank account like it's your own personal bank account and you are defrauding people. Fraud is often a big factor in piercing the corporate veil. But in this case, is it a problem? Probably not, but more so what you should do is don't directly fund those projects with your personal money. Use your personal money as a contribution to your business, and now the business is paying for those projects. So you make a member contribution, you write a check from your personal account into this business checking account, and then you use that business checking account to fund the projects. That would be the better way to do it. Hello, my trademark is dead from February 2025, so can I recuperate it? Probably not. I'm filming this video in June, and if your trademark has been dead from February of 2025, then it's probably too late. When something happens and a trademark becomes abandoned or canceled, we sometimes have an opportunity to revive it. In the instance of an abandonment, the USPTO will issue a notice of abandonment, and we will have 2 months from the date of that notice to revive the application. It's not always a guarantee that we can. Sometimes we aren't able to, depending on the circumstances, but if we can, we have to do so within 2 months from that date of abandonment. If it's dead because it was canceled, let's say because you didn't renew it, there is a deadline where you can correct that, revive it. I don't know off the top of my head. I think it's still that 2-month deadline. But again, the circumstances under which you're permitted to do that are pretty limited. Let's go ahead and say there's a 2-month window, generally speaking, to revive a dead application. In this case, it's too late. I'm sorry. I'm sorry. Businesses more often sell products under brand names which have nothing to do with the business name. That's true. That's true. A prime example of this is UGG and its owner, Decker Outdoor Corporation. The decision as to what should be trademarked is very simple. Only trademark what is used in commerce. So this isn't a question, but I'm including it because it's true and I like it. Your company name isn't always your brand name. It isn't always the trademark that you want to focus on. Like with, I haven't verified this, I'm assuming it's true, Decker's Outdoor Corporation is the company that owns the UGG brand. I assume that's correct. I'll go one step further. Only trademark what is used in commerce. That's true. But also, only trademarks are used in commerce. If it's not used in commerce, then it's not a trademark at all. Use in commerce is a requirement for something to be a trademark. So yeah, that is correct. Only trademark what's used in commerce, because you can only trademark something that is used in commerce. Lol, paid $44,000 in taxes, $290 more for Delaware LLC's pocket change. How broke is your audience? First of all, rude. Second of all, ew, rude. 200 pocket change. How broke is your audience? I don't know. I don't know how broke my audience is. I assume some of them might be broke. I don't think you have to be broke though for $290 to be a significant amount of money. I don't consider myself broke. I'm definitely not like rolling in dough, but I don't consider myself broke. But $290 ain't nothing. It's definitely not pocket change. What this question has to do with, I think, is that I don't recommend people register LLCs in Delaware unless they live in Delaware. People hear that major corporations are based in Delaware, and so they think, well, if the major corporations are doing it, I should do it too. But what works for massive companies doesn't often work for, you know, smaller operations, LLCs and stuff. So registering your company in Delaware, if you don't live there, typically just makes you have to pay more money than you would normally. I don't know about the $290 more. So what? I know a decent amount of people who are wealthy, and I don't think any of them would scoff at $290. Oh, pocket change. Who cares? Let's just throw it in the trash. This is a bad opinion. I'm putting it in here to highlight that just because people have opinions doesn't mean they're good. I don't think this person knows what they're talking about. If they paid $44,000 in taxes, sounds like that means they make a decent income. They could have a bad tax strategy too. Who knows? But this person, I assume, thinks that they know everything because they make a lot of money. And $290, ugh, pocket change. You guys are broke. Don't listen to those people. $290 is a decent amount of money. If you can save $290, do it. Invest it. Put it in your retirement account. Save it. Buy something that will grow your business. If I have a name that I wish to trademark, but I don't have a preferred logo as of yet, can I trademark the name so that any logos I come up with for that name will be trademarked? If you have the name, you don't have the logo yet, can you trademark the name? Yes. Yep, you can do a trademark registration for your business name. Doesn't matter if you have a logo or not. But will that protect any logos that you do come up with? Not necessarily. Doing a trademark registration for your business name as a standard character mark protects your business name, protects it on its own without regard to any design, how it looks. So when you use your trademark, your business name in a logo, the business name is going to be protected regardless of how it looks in that logo. But you're not really protecting the logo, the visual design element of the logo. You are, because you still have some trademark rights just by virtue of using them. But you know, you still want to ideally register the trademarks for your logo as well once you have it. But don't let that stop you from registering for the name also. I heard that BOI is no longer required. Is that true? As of now, yes, that's true. Man, the stuff with the BOI, beneficial ownership information, has been so up and down. The last I covered it, I think, was a video that I filmed in March, and I posted it maybe in June. And when I filmed it in March, BOI was required. And then by the time I posted it, it was no longer required. So this stuff changes all the time. As of now, beginning of June 9th, I'm filming this. As of now, BOI is not required for domestic entities, I think is the terminology. If you're a foreign entity operating in the US, then the BOI is going to apply in that instance. But if you're a domestic entity, so for the majority of us who our companies are formed here in the US, so we're operating in the US, then BOI is voluntary. Again, could change, who knows? By the time this video is posted, that may no longer be good. All right, last one. What I learned the most, get a lawyer. Thanks. It's not a question, it's a statement. It's a great one. I think that should be the biggest takeaway from all of my videos. Everything I've ever said. I hope if there's one thing you have learned from all up in your business, it's talk to a lawyer. Thank you. Sincerely, Laughter 1561. You've done the homework. You figured it out. You cracked the code. That's what you should learn. Get a lawyer. And with that, this episode is complete. I promised a little bit of an update on the future of All Up in Your Business. We're gonna be taking a break for a little while. Probably won't be any new videos for a while. Maybe another one here and there, but I'm gonna be taking a break for a little while, so you won't see a whole lot of me here around YouTube. You can still follow me on Instagram. I don't post personal stuff there all that often, but every once in a while, I might post shorts here and there on YouTube, and like I said, maybe I'll pop up every once in a while, but you know, I'll be gone for a bit. You know, just got some personal things that I'm gonna have to tend to for the next bit. Got some other stuff going on that I'm gonna have to focus my attention on. So this isn't goodbye forever, but it will be I'll see you soon. In the meantime, like I said, keep up with me on Instagram and stuff, and keep the comments coming. You can find more info, you know, stuff from me down in the description, like my trademark course, Brandish, if you need help with that. I'm not taking any new clients for a while either. Maybe around the beginning of 2026, that will change. But in the meantime, thank you all for all of the support you've given me over the last 10+ years. Thanks for continuing to come back and watch my videos. I'm not going away forever. You'll still see me pop up here and there, I'm sure, but for a little while, I'll be gone. All right, that's all for this episode, folks. Thank you so much for watching. I'm Aiden Durham, and I will see you next time.